I'm Hannah from PUP College of Law, your host for today. Welcome to CentralBooks' Best Pre-Week Ever Season 3, our annual lecture series in partnership with the Philippine Association of Law Schools, bringing together the leading legal educators and practitioners to help you prepare for the bar. For this session in commercial law, our lecturer is Judge Rocille Aquino-Tambasacan, the presiding judge of RTC Branch 21 in Imus City, Cavite's Commercial Court. A former senior assistant city prosecutor of Manila, she is an award-winning prosecutor, a longtime commercial law professor, and a sought-after bar reviewer. She is also the author of several commercial law references and a recognized expert in intellectual property, having received specialized training in Japan and represented the Philippines at the Colloquium for Teachers of Intellectual Property Law in Geneva, Switzerland. Let's all please welcome Judge Rocille Aquino-Tambasacan.
Okay, good day. Kung saan mo kayo lupalop, nakikinig, tsaka nanonood. So, you're watching now, you'll be watching my pre-weekend commercial, the annual thing I do. And if you have no materials yet, my pre-week with Central will be surely out in the market already. Okay, you can buy it. Now, on display are my other books in commercial law, which were published this year, which you can also use as your reference. Now, this pre-week would be covering two kinds of topics. First would be Justice Garland's rulings, plus the current doctrines that are in the cutoff. Kasi alam niyo naman natin na pag nagba-bar exam, laging kinukuha nila ay most recent rulings, which are actually not really new. These are only interpretations of the old rules, although there are some which are not really that new. Okay? So we start off with corporation law. Hoy, ito'y pre-week. Kaya wag niyong isipin lahat i-discuss. We will all discuss the salient matters. Okay? So, in corporation law, we have a Justice Garland ruling. This is about separate juridical personality concept. So, in the case of De Leon, what happened? So, Attorney De Leon is the president of a bank, and he signed an assignment of mortgage in behalf of the bank. It turned out that the property was bought by a third party from Prosecor. So, there's a dispute about the ownership of the lands. In the meantime, the bank was already dissolved and Attorney De Leon is also resigned from the bank. So, Lacuna sued Attorney De Leon for the delivery of the title. So, should Attorney De Leon be held liable? Personally, okay, let's go back to the concept. What is that concept? The concept of separate juridical personality. So, the obligation is on the part of the corporation, not personal liability of the officer to deliver the title. Why? The separate juridical personality concept. So, the corporation is separate and distinct from the person behind it. And as a rule, directors, officers, stockholders will not be held personally liable for obligations of the corporation. However, there is an exception, piercing the veil of corporate fiction. So, ito yung traditional piercing the veil concept na ginagamit natin. It's still the same concept when the fiction is used for what purpose? To perpetrate fraud as a vehicle for the evasion of existing obligation, circumvention of statutes, or to confuse legitimate issues. So with the facts earlier given, anong nangyari? Attorney De Leon merely signed because he is the president. So can he be held personally liable? It is not one of those instances. Okay? He only signed in behalf of the corporation. So there is no personal liability on his part. There's also another Justice Garland ruling. Still the same concept, the Makati construction development case, where the president also sued together with the corporation because there was no payment of the fees of a broker. The president signed because he was the president. So, going back to the question, should the president be held liable for the unpaid commission? The answer is no. Why? Again, under what circumstances will the corporate officers, directors be held liable? When you look at Section 30, Section 30 enumerates liability. And this enumeration, which you see in the slide, can be broken down into the following. First, when directors and trustees or the officers vote or assent to patent the lawful acts, or when they act in bad faith or with gross negligence, or guilty of conflict of interest, or when the director or officer has consented the issuance of watered stocks, or who have knowledge, did not file objection with the corporate secretary. Ano ba yung water stocks? These are stocks issued for less than adequate consideration. What else? When the director, trustee, or officer had contractually agreed to hold himself personally and solidarily liable, or when the director, trustee, or officer is by specific provision of law made personally liable. Here, again, none of these circumstances are present. He only signed because he is an officer. Before he can be held liable, the complainant must allege in the complaint these unlawful acts, or that's gross negligence or bad faith, and there must be clear and convincing proof of the same. So, because these elements are not met, there's no liability on the part of Olivares just by signing as a corporate officer. Okay? Madaling intindihin. Now, meron tayong bagong doctrine. Well, hindi naman talaga ito entirely new. Kasi meron tayong foreign jurisprudence. Pero locally, we have the doctrine of corporate opportunity. Okay. This is the top cross ruling which I've been waiting to be asked since last year. Under the doctrine of corporate opportunity, what does it say? If there's a corporate business opportunity presented to corporate officer, the obligation of the corporate officer is not to take it. It belongs to the corporation. So when he takes it for himself, he will be in conflict with the interest of the corporation. He is not allowed to get it for himself. So parang, well, we have a biblical saying here, a man cannot serve two masters at the same time. So the corporate officer must serve the interest of the corporation and not his own interest. So what's this Chang Tapros case? Chang. In Tapros versus Chang, Chang is the president and GM of Tapros. The business of Tapros is office equipment and supplies distribution. Since Chang was close to the family, the owners of Tapros, he was allowed to form corporations, 3 corporations, which are engaged in the same line of business of Tapros. But as an effect, the sales of Tapros went down because it went to these 3 entities. The argument of Chang is that the T family, the owners of Tapros, had allowed him to do it. So parang estopel ang argument niya. Can we apply estopel? For the elements, the doctrine to apply, we look at these elements. First, the corporation is financially able to exploit. The opportunity is within the same line of business of the corporation. The corporation has an interest or expectancy. And by taking the opportunity for its own, the director, trustee, or officer will be placed in a position inimical to his duties to the corporation. So using all of these elements, okay, can Chang be held liable? Here, there was no requirement. There should have been allowance. How is it allowed? It was not via estopel. There should have been votation by 2/3, ratification by the stockholders. Mere tolerance or knowledge of the T family is not enough because the law requires ratification. So since there was failed to ratify, the income should then be accounted in favor of Tapros. Now, how can this be asked differently? Kasi ito obvious naman na sagot because the business of Tapros is the same as that of Chang. Okay. What if, say, it's a restaurant business, the business of Tapros, and Chang would be opening also a restaurant, pero karinderya type. Kasi yung business ng Tapros ay yung mamahalin, 5,000, 4,000 per head a dinner, and not a karinderya style. Will there be violation if the nature of business is changed? Although pareho silang food, one of the requirements under the doctrine is that to be in competition, the two corporations must be engaged in related areas of business, producing the same product with overlapping markets. So even if they are both food, engaged in food, they don't have the same products. They don't have the same market. Why? Because the person who will eat in the carinderia is not the same person who will eat in the Gordon Ramsay style restaurant. In the same way that one who dines in the Gordon Ramsay style restaurant will not dine in carinderia because that is the requirement. They must have related areas of business. Paano pa ito pwedeng i-twist? Okay, assuming the same kind of business, restaurant din, same kind of restaurant, pero yung restaurant ay, say, lalagay sa Jinsan, and the restaurant is, of the corporation is in Metro Manila. Can there be a violation, considering that both are restaurants? There is also an element in the doctrine, which is financial ability to exploit. So even if they have the same line of business, but it was not proven that the corporation can exploit the opportunity, can go even to Jensen to operate, that will be that will be material in your answer. Okay? There must be proof of financial capacity to exploit the opportunity. Watch out for this Topros versus Chang case. Okay? Now, there is also a new doctrine on derivative suit in the case of Ago Realty. Can majority stockholders institute derivative suit? In the case of Ago Realty, the one who's running the corporation is the minority, Angelita. And the majority, Emmanuel, are opposing the action of Angelita because Angelita introduced improvements over the corporate property and there is no board approval. So what are the requirements for derivative suit to prosper? So number one, the person must be a stockholder member at the time of the action and at the time of the filing. So at the time of the acts complained of plus the time of filing, exertion of all reasonable efforts. So exhaustion of all administrative remedies as embodied in the articles, bylaws, or rules. No appraisal rights are available. The case is not a suit nuisance or harassment suit because if it is one, the court will dismiss the case and it must be brought in the name of the corporation. So here, before instituting a derivative suit, all efforts to exhaust have been undertaken. Here, ano bang nangyari? Sinabi ko, di ba, nagreklamo yung majority over the minority. Emmanuel said that they tried to talk, but Angelisa walked out. Is this enough? No. Why? Because you must refer to a provision under the articles or bylaws for dispute resolution. If you fail to point out this, then that is a ground also to dismiss the case. Now, the easiest way that Manuel should have taken is for the board itself to institute a suit. But how come the board did not institute suit? Because there was no board in the first place. Had a board been set up, there's no need to go through a derivative suit. So, board sanction litigation takes precedence over derivative action. But this could not happen because AGO did not create a board. And they cannot just circumvent the provision, shortcut the procedure via a derivative suit. Okay? So this is the landmark case saying that if you are the majority, you cannot institute a derivative suit. Okay? Now, in the case of Metrobank, this is also a landmark case. This is a new recent ruling. Here, there was a loan obtained where Salazar Realty guaranteed the loan by a mortgage of all or substantial of the property. So when Tacloban failed to pay the loan, there was a foreclosure. But the other incorporators filed a derivative suit saying that the mortgage covers all and substantially all of the assets. And this requires stockholder concurrence. So let's go back nga pala sa nature of derivative suit. Suits can be of three kinds, depending on who is the aggrieved party. It could be an individual suit, a class suit, or a derivative suit. Example, If you're a stockholder, you're denied the right to inspect, then that is a wrong where only you are concerned. So it is an individual personal suit. It can also be a wrong done to a group of stockholders. Example, if a group of preferred stockholders are violated, then a class suit can prosper. But if the one who's injured is the corporation itself, the cause of action belongs to the corporation and not to the individual, then a derivative suit can be filed. Okay. So, normally, derivative suits are filed for mismanagement or wrongful act of the board of directors because the board will not sue themselves. Now, let's look at the case of Metrobank. In Metrobank, we have said that it requires a concurrence of the stockholders. In the requisites of a derivative suit, which is similar to the discussion ago realty, this 5 was already mentioned. Anong nakalagay dito? Diba? No exhaustion of all remedies are available are done and there's no appraisal right. So here, there is failure to comply with the requirement, which is regarding the availment of appraisal right. If you mortgage all substantially of corporate property, it is one where there is a stockholders action. Here, there was failure to make particular allegations regarding availment of appraisal right or impossibility or futility thereof. So, the derivative suit must allege that there is no appraisal right available against the corporate action because if there's appraisal right, then that should have been done by the parties. Di ba tandaan nyo sa instances where appraisal rights are available? Di ba at same ang acronym natin, amendment of all or substantial, amendment including revision of provisions of material provisions of the articles of an incorporation. So amendment of the articles. T is term, which is also found in the articles. S is sale, lease, or mortgage of all or substantially all of corporate assets. I is investment, which is not the primary business concern, and M is merger and consolidation. Diba? At SIM. So, amendment. But saan to papasok itong Metrobank case? Papasok siya doon sa at SIM. S, sale. So, in that instance, at SIM, it should comply with the requirements. So here, if appraisal rights are available, then that must be alleged. The non-availment must be explained. Kasi, nakalagay, all resolved efforts should have been banked. So here, in Metrobank, there was failure to comply with exhaustion of all remedies. Kasi, it is one of the instances where appraisal right is present. Also, the petition must contain a statement that it is not a nuisance or harassment suit. And it must categorically declare under oath that it is not being used as a means of nuisance or harassment of a party. So maganda tong Metrobank case for you to watch out regarding exercise of the derivative rights of derivative suit. Now, let's go to partnership. Sa partnership, lagi kong sinasabi to, ang partnership ay subject na, kumbaga sa pamilya, hindi siya paborito anak. Kasi bihira lang magtanong. Tapos kung magtanong, nasa-zero in natin. Ano yung questions? So, the questions normally are all about the obligations of partners among themselves. Number 1 will be regarding engaging in business. We have to qualify an industrial from a capitalist partner because on the qualification of business. An industrial partner cannot engage in business for himself because all of his labor industry must be for the partnership. But for the capitalist, we have to qualify. Okay? Because capitalists can engage in business if it is not in the same line of business where the partnership is engaged. Okay? And what will happen if there's a violation? Then profits obtained, the funds will accrue to the benefit of the partnership, and the partner liable will not share to the profit and must personally bear all the losses. Okay. So, let's take an illustration. Kasi lagi naman ganun pag tinatok sa bar, laging may illustration. If the business partnership is a car wash business and the industrial partner opens a salon, normally ganito na kasi ang partner, ang mga car wash, may katabing salon, tapos may katabing coffee shop. So the coffee shop is run by the capitalist partner. Can the capitalist partner engage in a coffee shop business? Can the industrial partner open up a salon? For the industrial partner, I've said, he is required to perform his entire industry for the partnership. So the capitalist can engage in a coffee shop because it is not the same line of business. But the industrial, no, because he is required to devote his full time. What if we change the problem? Instead ng negosyo ni capitalist a coffee shop, naging car waxing business. This time, there will be a change in answer because the car wax business is somehow related with the car wash business because they are in competition. Car wash businesses offer also buffing and waxing. So it being related to the business of the partnership, it will also violate, similar to the corporation, the corporate opportunity doctrine. So we can apply the concept of corporate opportunity in partnership and corporation as well. Although the jurisprudence we have is all about corporation. Pero pwede naman sa partnership kasi entity rin naman yung partnership. Okay. How else is this questions on partnership being asked? It's asked via sharing of profits and losses, liability for profits and losses. Okay, let's take an example. Obvious naman kung sino ang aking favorite anime kasi kahit sa background ng video, kita nyo naman ang nagkalat kong Sailor Moon. Kung hindi nakikita, bulag kayo. Okay. Now, first, assuming, okay, capital is a Sailor Moon, 500,000 yung kanyang capital. She's also the managing partner, and there's an agreement among them that her liability is only up to the extent of the capital. Sailor Mercury is a capitalist, contributing 500. Pareho kay Sailor Moon. Sa Sailor Venus, ganoon din, 500,000. Pero sa Sailor Mars, they agreed that she is the limited partner for 1 million. But they agreed that she is also a managing partner. Do you see something wrong with that? Yeah. Now, Sailor Jupiter is the industrial partner, and there's an agreement that she will not be liable for losses per their agreement. So, assuming the partnership earned 800,000, and they agree that the just and equitable share of Sailor Jupiter, the industrial, is 100. Paano paghati-hati ng 700,000? So, this was asked in the bar. Ang sagot ay math. Kayo nag-law, ayaw nyo ng math, ay problema nyo ngayon. Paano mag-compute? Kasi 700,000, how is it distributed? Ratio and proportion. And the 1 is to 1 is to 1 is to 2. Kasi 500,000 versus 1 million. So, the 1 over 5 and 2 over 5 yung hatian over times 700,000. So mathematically, that's 140 for all except Sailor Mars kasi sa kanya 1,280,000. What if the partnership did not earn an income? It has a loss. So how will be the sharing made? Eh di ganun pa din. Ratio and proportion na 1 is to 1 is to 1 is to 2. However, the difference is that Sailor Jupiter, who is the industrial, will not share. Remember, industrial partner siya, kaya hindi siya liable for losses. So, the amount will be, again, 1 over 5 times 800, which is 160. And let's change the scenario. What if the partners decided to dissolve the partnership? Tapos, after the sale of the assets, may utang pa sila. Ang utang nila, 300,000. So, how will 300,000 be shared? Look at the agreement of the parties. The agreement is that Sailor Jupiter will not be liable for the losses as per agreement. And Sailor Mars is a limited partner, but a managing partner as well. Even if Sailor Mars is a limited partner per agreement, this is not correct because a true limited partner must not be a managing partner. So Sailor Mars will be held liable also in the story. So proportionate din ang liability. Now, so far Sailor Jupiter, there is an agreement that she is not liable for only for losses. She could be held liable. This is not a loss, ha? This is an unpaid credit, utang. So Sailor Jupiter will also be held liable proportionately. What if the parties had agreed that she will not really be liable? This agreement is only binding among the parties. Even if there is an agreement, the agreement is only within them. So third parties can go after Sailor Jupiter, but once Sailor Jupiter pays, she has the right to be reimbursed by the rest. So liability will also be proportionate in character. Okay? So now, another way this is being asked is via rules as to management. The one who would manage is the managing partner appointed the articles. This powers are revocable if he was appointed in the articles. So he can just be removed except if there's just or lawful cause, just bad faith. And the vote of the partners representing the controlling interest will be necessary for the revocation. And the power granted after partnership had been constituted can be revoked at any time. So let's look at controlling interest. Controlling interest is not the number of persons. It refers to the amount of the interest. So kung mas malaki yung ambag mo, mas malaki yung share mo, mas malaki yung votation mo. Hindi to parang Christmas party sa law school. Kung sino pa yung walang ambag, siya pang mas madaming kinain. Okay? Hindi ganun yun. So, let's take again an example. Halata na naman sa edad ang aking example. Okay, anyway, meron na naman akong display na dyan, Bioman. Okay. So, red one is a capitalist, contributing 500,000, managing siya. Green 2, capitalist, 1 million. Blue 3, capitalist, 200,000. Ang gustong i-hire ni red 1 is yellow 4. Ang gustong i-hire ni blue 3 ay si pink 5. Whose choice will prevail? It is the choice of the managing partner. Why? Because hiring is one of the powers of a managing partner. Assuming that si Blue 3 ay managing partner din. Ang contribution niya 200. Si Red 1 capitalist and contribution niya ay 500. So ibig sabihin ba dahil si Red 1 500,000 ang binigay, mas may right siya over kay Blue 3? Hindi, kasi pareho lang silang capitalist. Okay? So how will the stalemate be broken? Well, it's via the vote of the one having the controlling interest. And the one having controlling interest will be, in the example, green 2. Kasi siya may pinakamalaki. Okay? So rules as to management, I've said that earlier. What if, a partner decides to assign his share to someone else? Does it mean that this third person is already the partner? That is the doctrine of delectus personae. A partner cannot be forced to accept someone else as his partner, his choice of person. So if a partner associates, assigns a share to someone else, the assignee is not admitted to the partnership. The right only of the assignee is to receive the share of the partner, but he cannot exercise the right of a partner. Example, si Emerald, industrial partner, Sagato, capitalist. And then a deed of assignment was executed in favor of Lantis by Zagato. So does it mean Lantis can interfere in the management and inspect, and records. These are the rights of a partner, and the assignee cannot exercise it. The assignee has only the right to receive the share in the profits, but has no right to interfere in the management nor to inspect reports because it is the partner only who can do so. Okay? So, pag magtanong sa partnership, alam ko, dito lang iikot ang tanong. Wala nang iba. Now, for insurance law. Sa insurance, ang tinatanong na number 1 ay insurable interest. Kung may magtatanong na tanong, isa lang yan, ay sigurado ako pustahan tayo, yan ay insurable interest. Okay? What is insurable interest? Okay, well, the continued existence of the thing or person, you're deriving pecuniary benefit. When the thing is lost or destroyed, when the person dies, the person also sustains pecuniary loss, and that is insurable interest. Pwede ba yung creditor and debtor magkaroon ng insurable interest sa creditor over the life of the debtor? Well, yes, because if the debtor dies, then there will be no payment of the debt. That's why the creditor has insurable interest. But the question is, up to what extent? This is a new case. Sabi ko lagi, kahit nung last year pa, bantayan dahil this is the landmark case on creditor-debtor relationship, the case of De La Fuente. How does this case went on? May nangutang ng 3 million, meron siyang lending business. So si debtor na nangutang, kumuha siya ng insurance na 15 million. Nilagay niyang beneficiary si creditor. Ang utang niya simula 3 million. Nanganak na nanganak, naging 16 million. Nagkaroon ng partial payment, naging 14 million actually. Namatay si debtor. So, the creditor now is trying to recover. But the question is how much? Is it 3 million at the time the loan was taken? Or should it be 16 million or 14 million? Kasi may partial payment na nga pala ng 2 million kaya 14 million. The creditor's insurable interest is the outstanding obligation at the time of death, not the time at the policy was taken. Why? Because when the debtor takes an insurance, he's using the policy as collateral. Therefore, since the policy is a collateral for his debt, then it will only mean that it will be the outstanding obligation or loan at the time that he dies. So, he can recover 14 million kasi may partial payment na doon, 2 million, kaya hindi 16 million. So, what's the difference between the two? If the insurance is taken by the debtor on his life, payable to the creditor, or an insurance taken by the creditor on the life of the debtor. Okay. If the debtor takes an insurance on his life and pays the creditor, payable to the creditor, and the loan is fully paid, where would the proceeds go? It will not go to the creditor. It will go to the estate of the debtor. What if the one who took the insurance is the creditor and the loan is already fully paid? Can the creditor get it? Siyempre hindi. Wala na siyang insurable interest kasi it was already fully paid. Can it be given to the estate of the debtor? No, because the debtor is not a party to the contract. The one who took the insurance in the story is the creditor, not the debtor. So take note of this De La Fuente case, distinguishing insurable interest of the creditor and debtor. Meron din tayong bagong kaso dito, the case of Land Bank versus Miranda. Okay, it's about an insurance policy on, or there's a mortgage redemption insurance. Here, there were borrowers, Miranda together with the spouses Fox. So Miranda submitted as security for the loan a property. They were required to take an MRI, mortgage redemption insurance. But these people did not sign or fill up the form. So, during the subsistence of the loan, one of the borrowers, Robert Fox, died. So, si Miranda, akala niya dahil namatay, may MRI, the MRI will take care of the balance of the loan. So, hindi siya nagbayad. However, her property was foreclosed for non-payment of the loan. And the argument of Miranda is that there is an MRI. They have a sort of deduction now, 5,700 representing insurance premium. So, is this correct? Was there an MRI? So, in the problem given, the law mentions of an MRI. An MRI is actually a type of group insurance made to protect the parties, the mortgagor and the mortgagee, so that if the loan is not yet paid and the debtor, borrower, mortgagor dies, the proceeds of the insurance will be applied to the loan. Here, was there an MRI? MRI, being a contract of insurance, requires concurrence of the parties. So, the concurrence of the insurance company is not given when it simply receives the application form. There must be an issuance of the policy as well as payment of the premiums. Here, ano nangyari sa facts? They never applied for an MRI. They were given the form, but they did not fill up. And they said that 5,700 was paid, but this was not accepted by the insurance company because the MRI cover consumers loans and does not cover the kind of loan applied by Miranda. And the insurance company never issued an insurance policy. Therefore, there is no insurance coverage. So, take note that insurance contracts are contracts. So there must be consent, object, and cause. So since the insurance company did not consented, did not issue a policy, then there is no binding contract of insurance. Kaya, the foreclosure of the property is warranted. So, kung may tanong sa insurable interest, saan pa pwede magtanong? Incontestability clause. Okay. Ano yung incontestability clause? We have elements. First is that it must be a life insurance policy, payable on the death of the insured. The policy is in force for 2 years from issue date or last reinstatement. The policy could not be long proven void or rescindable by the insurance company, and the grounds are only limited to concealment or misrepresentation. Take note of the grounds. So, paano kung ang issue ay sinabi ng sa application nilagay mo na you are husband and wife. So, you are taking insurance on the life of your wife, ikaw husband. Pero it turned out na hindi kayo husband-wife kasi kabit mo yun. Yun yung asawa mo, yun yung common law spouse mo kasi ikaw ay hiwalay sa asawa, so may kabit ka, kumuha ka na insurance doon sa kabit mo. Pwede ba yun? Well, the grounds are only limited to concealment or misrepresentation. The ground here is lack of insurable interest. So if the ground is lack of insurable interest, di mo pwede gamitin itong incontestability clause. Tandaan, is only concealment or misrepresentation, like not disclosing your true state of health. That is most of the time the cases decided by the Supreme Court. Okay? Take note also that IC is only applicable to life insurances, not to property insurances. Okay? We have a sort of problematic ruling regarding incontestability clause. Kasi lahat ng mga Supreme Court cases, even bar exam case in the past, have the same factual setup. An insurance being taken, the insured dying more than 2 years later, so more than 2 years had lapsed, or dying and the discovery was made wala pang 2 years or after 2 years. So madali lang noon ang problem. Magbilang ka lang ng 2 years, incontestable na, right? They never used or never took a look at the impact if the insured dies before the 2-year period had lapsed. Basta, tapos na yung 2 years, whether or not the insured is dead or alive, the policy is incontestable. If the insured is if the insured is alive or not, is immaterial to the resolution of incontestability clause. They only look at the period. Then comes Sun Life versus Sibia. In Sun Life versus Sibia, the insured died before the 2-year period had lapsed. He did not say that he had treatments at the National Kidney Institute. So he died 3 months after issuance of the policy due to a gunshot wound. Ano sabi ng Supreme Court? Well, the Supreme Court said that if the insured had died before the 2-year period prescribes, the policy is already incontestable. So, hindi tayo nagbilang ng 2 years. In short, the 2-year incontestability period can be reduced to a period less than 2 years if the insured dies. So, paano ngayon natin i-resolve? Hindi naman sinabi ng Sun Life versus Sibia na we are already abrogating a ruling in TAN, etc. It is as if all other rulings did not exist. I always give this advice. If this question is posed, you answer the traditional answer, but only add the Sun Life versus CB ruling as a secondary answer. One sentence lang yan eh. Huwag itong main answer ha. Kasi even this is the most recent jurisprudence, it did not say that we're already doing away with the ruling in this case. No. It is as if the other rulings did not exist. And number 2, the CB ruling is just a division ruling, not an en banc. And there was no categorical statement that the Supreme Court is already abandoning the old ruling. Hindi tulad siya ng Collin case sa intellectual property na sinabi talaga we are abandoning. Okay? So take note of this case. Next would be reinsurance. Itong reinsurance, bibihira lang kaso natin dito. Okay? And yung nag-isa pa natin kaso, discuss the concept of follow the fortunes or follow the settlements doctrine. Okay. What is the background of the FLT Prime case? In reinsurance kasi, di ba, the insurance company takes an insurance with another entity, and this entity will ensure the probability of the original insurance company being liable to the insured upon the happening of the peril. So that's why it is insurance in reinsurance, you are insuring an insurance. So FLT Prime issued to Top Forest a fire insurance. FLT Prime reinsured itself with solid guarantee. Fire destroyed the property, kaya there was a claim. So FLT Prime paid, but solid guarantee refused to pay up FLT Prime, saying that the amount was inflated. In reinsurance, we have follow the fortunes or follow the settlements doctrine. What does it say? So the reinsurer is bound by the reinsured's decision on payment as long as the decision was made in good faith, in order to prevent the reinsurer from second-guessing the settlement decisions. And it's the reinsurer who has the burden of proving bad faith. Here, we got the follow the settlements or follow the fortunes involves judicial determination of bad faith in handling the claim. But what happened in this case is via a summary judgment. And summary judgment is not proper when there is dispute of the data and records used in evaluation. This should have been decided via a full-blown trial on the merits, not just a mere summary judgment. So, hindi nag-apply dito ang follow the fortunes or follow the settlements rule. Okay. Isa pang tanong dito on insurance is about rescission and concealment. Okay? So, kasi kanina, sa incontestability clause, under din yun ng concealment. So, the insurance contracts can be rescinded in case there's concealment and misrepresentation and violation of a warranty. So, although nilagay ito sa bar syllabus natin sa bandang dulo, pero din discuss naman ito all together when we go to concealment, misrepresentation, and violation of warranties. Kasi pag natanong sa bar, unang tanong is insurable interest, and normally, it's concealment, misrepresentation, incontestability clause. Now, let's go to transportation law. Sa transportation law, ano ang number 1 tinatanong? Walang kamatayan private and common carriers. Distinguish one from the other. So from the definition, you see that a common carrier's job is to transport goods by land, water, air, or cargo or people for compensation, often in service to the public. Naka-underscore yung public kasi pag private, hindi yan public only, particular instance only. But the law to be used for private carriage will be the ordinary contracts in the Civil Code. For common, you use the Common Carriage provision of the Civil Code, the PSA, as well as other special laws like COGSA, like Montreal Convention. And the degree of diligence for common carrier is mataas. Extraordinary diligence. So, private is only diligence of a good father family, ordinary diligence. That is why in common carriage, if the person dies or injured, it's automatically presumed that the common care is the one at fault. There's no distinction anymore between a main business or a sideline or ancillary or one who does it on a regular basis or only scheduled, episodic, or one who gives it to everyone else, to the broad public, general public, only to a narrow segment of society, because that's still considered a population. So, what if the client is limited in character? These are all already answered, yes. Even if you are a customs broker, handling of transportation is part of the services of a customs broker, even if ancillary, kaya common carrier pa rin siya. Even if the school bus only caters students of a particular school, kasama pa rin siya. Or a beach resort which has ferry services on top, and there are some guests who does not take the ferry, that's the cruise versus Sun Holidays case, twice as in the bark, ganoon pa rin, common carrier pa rin siya. How about online booking? Diba, sumakay tayo ng Grab or yung padala, Lalamove. This Grab, Lalamove, Angkas, are they common carriers? That's the issue between TNC and TNVS. TNC, Transport Network Companies. TNVS, Transport Network Vehicle Service. So, TNVS refers to the vehicle owner using the app. TNC refers to the entity which provides the transportation services. So, TNC provides the technological infrastructure. So, Grab, Lalamove, Joyride. TNVS is the vehicle owner. So, both are required to exercise the due extraordinary diligence because both are common carriers. One provides the technology, the other one handles the actual transportation of the person or the goods service provider. In the case of Valenzuela, ang argument ng CAS ay they are not common carriers because they can only give their services to those who are online. So you must have the app, you must have downloaded the app. So they are not now common carriers. That is wrong. Even if you cannot hail them on the street, because when they log in, they automatically make themselves publicly available to anyone who's likewise online. And the people who are likewise online are considered still part of the public, although a narrow segment of society, those who have the app, who have downloaded the app. E paano ngayon kasi merong mga may bago ngayon eh. Paano kung baguhin natin ang bar problem, gawin natin in-drive? Kasi in-drive daw ay if you book in-drive, there would be a choice. The driver of the in-drive could choose who will be its passengers. The passenger can also choose the driver. Hindi siya like daw Angkas and Grab where you have no discretion kasi it's the app which is automatically pairs up the two. What if ganong setup ang sabihin natin? Bago natin, bar exam purposes. Tingin ko hindi magbabagong sagot. Bakit? Because again, even if there is a choice between the driver and the purported passenger, it's not a true choice because they're only confined to those people who are within the app, within the system. They cannot get anyone outside the app. And of course, there's also a limitation on the selection of passengers and drivers as well as on the cancellation. So there is no true choice on this contractual relationship between the parties. Okay? Now, for safety of passengers, sabi ko nga, common care is extra of the highest degree. That is why if a passenger is injured, the person dies, cargo is lost, automatically it's the fault of the common care. The burden then is shifted to the common care because the passenger wouldn't have to prove that there's a contractual relationship and it happens in the existence of the contract. For example, sumakay ka ng bus, nagkaroon ng accident. The only thing that you have to prove is that, to say that there's a breach of contract of carriage is that you are a passenger, and it happened during the existence of that contract. But what if fortuitous events come in? Okay, because these are the logical excuses being used by common carriers. Example, Titanic, fortuitous event ba ito? Tumama sa iceberg. Not just because Mother Nature is the picture, sasabihin nyo na fortuitous event, hindi. Because if there is an errant human element, hindi na siya fortuitous event. Okay? So, Titanic sunk not because of the iceberg. It's because of the failure of the captain and crew to see the iceberg ahead of time. Kaya ang tama sa Titanic ay tagiliran. Okay, so, like in the case of cruise versus sun holidays, malakas ang alon. So, is this fortuitous event? No. Because during that time, big waves are anticipated. These are normal. Okay? Volcanic eruption, the case of Japan Airlines. Volcanic eruption cannot be predicted. However, the problem here is the failure of Japan Airlines to make the proper arrangements for the passengers. The passengers were not properly classified. Since they are continuing passengers, they should not be classified as new passengers kaya hindi sila nakasakay. Okay? For fortuitous event, carriers are not insurance companies. They do not undertake that you arrive safely at the point of destination at all times. As passengers, you must undertake the usual peril which a passenger would experience. So, mga examples, lahat ng anything about wear and tear is not a fortuitous event. Okay? If there was hijacking, again, kaninong fault yun? Fault of the carrier. So, it cannot be used as fortuitous event. It just so happened that we have a Supreme Court case in the past where there was hijacking pero hindi kasalanan ng airline company because of the situation then. It was martial law and the one who are checking the passengers and the baggage are not the airline company representative but the soldiers. What happens then if the passenger paid discounted fare or the passenger or there were notices? When a passenger, when there are notices placed, it does not mean that the common carriers relieve liability. And if a passenger is carried for free, it is not also it also does not result to a limitation of liability. Okay? In gratuitous, a stipulation limiting liability is valid but not for gross negligence, only ordinary. Fare reduction will not justify it, but for a stowaway is a trespasser and assumes all the risks tenanted. I have one last question over this. I have this chain question so that you will not forget ano yung application mo. So, may driver, may jowa si driver, lahat sila sumakay dito, mayroong isang pasahero na may credit card company pass na binigay, senior citizen, may walwal, may born-again preacher, at meron ding hold-upper. If they are all injured, can the carrier be held liable? So, insofar as gratuitous carriage, ano sabi natin kanina? If there's an agreement stipulating liability, it can be lowered. But here, there's no stipulation. Therefore, the common carrier be held liable. The driver is not, remember, a passenger. A driver represents the common carrier. Um, how about one who paid using a pass? He's still a passenger. And that is not gratuitous because someone paid for that person. Similarly, a senior citizen who pays should receive the same benefit as that of a full-paying passenger. Hindi porke sumakay ka sa Cebu Pacific piece of fare, ikaw bumili ng piece of fare, ang katabi mo bumili ng full fare, ikaw yung itsuchugi. Okay? Pantay lang kayo. So, your profession is also immaterial. Whether you are a born-again preacher or hold-upper, that's your profession, you're still a passenger. And of course, the walwal is just a stowaway. Now, what if it's caused by the actuation the damage is brought about by the acts of a passenger or the acts of an employee? In the case of LRTA, it's caused by the manong guard. And the guard who boxed the passenger, the guard represents the carrier. So, when this was asked, by the way, in the bar exam, binago na lang facts. They made it appear that it's really the manong guard who boxed him. That the actual LRT case said that there was no boxing by the guard. There was no evidence to show it. If it is caused by a passenger, what if the altercation has nothing to do with the contract of carriage? Like, kaya nag-away yung driver at pasahero, hindi na sa pamasahe. Dahil magkapit-bahay pala sila. Okay? So, will it matter? No. The only requirement is passenger and employee because the new civil code says absolute liability. Okay? No qualification anymore regarding the reason for the altercation. Basta the one who committed, it is an employee of the common carrier. For actuation of strangers, similar to passengers, there's the requirement that if if there's exercise of a good father of a family, they could have prevented it. In the case kasi of the heirs of Batu, where the passenger shot the fellow passenger, there was no basis on the part of the bus driver or the conductor to make a bodily search on the passengers. So there can be no liability in the part of Florida. Pero again, for bar purposes, what if it was not enough facts? Like nag-away muna sila pala sa loob ng bus. Tapos after a while, nagbarilan. Iba nang sagot nun. Kasi there should have been more stringent measures made like precautions, wag silang pagtabihin o bantayan and the like, which was not made by the driver and the conductor. Now, the last topic for transpo will be Montreal Convention. Montreal Convention supersedes Warsaw, but there's still some common provision. This applies to international carriage. So international mean the place of departure, place of destination are different. What if there is this one Supreme Court case? The tickets were bought in Bangkok and the travel is from New York to Chicago to LA. Will Montreal Convention apply? The states I mentioned are all within United States of America. Okay? So this is not international carriage. That's why you cannot apply Montreal Convention because the territories are just the same. Pampagulo lang sa facts yung bumili ng plane ticket sa Bangkok. Remember, place of departure and destination are two different countries to be international carriage. Ano yung bago sa Montreal? Kasi hindi pa nagtatanong sa Montreal. Noon na nagtanong sa airline transportation, pero hindi naman waras ang tinanong noon eh. It's about application of civil code pa rin on whether or not there's a contract of transportation. Now, paano pwede magtanong? Kasi may bago. Okay. Regarding liability. Because under the Montreal Convention, the carrier is liable for death, wounding, or bodily injury if the accident took place on board the aircraft or in the course of embarkation or disembarkation, and there's a two-tier of compensation. It's up to 151,880 SDR without need of proving fault. If you would go beyond 151,880, the carrier can avoid liability by showing that it was not due to negligence of the carrier or servants, and it was due to a third party. So if the claim is below 151,880, no need to prove fault. Okay? Above that, there can be a defense on the part of the common carrier, the part of the airline company. SDR, hindi na tayo francs ha, SDR na, special drawing rights, which is a basket of 5 currencies. Paano kung ang nangyari ay the passenger was not allowed to board because the tickets were not properly endorsed by Palto Singapore Airlines? So, will this scenario be covered by Montreal? Hindi. Because it happened before the flight. The law requires during the performance of the contract of carriage, but this happened before the flight. They were not accepted. What if the injury is not physical? It's psychiatric. No. The law requires bodily injury only. Other than that mentioned amounts, can a party ask for damages beyond the provision of Montreal Convention? Yes, because the law did not operate as an exclusive enumeration of liability of the airline company. It is not borne by convention because if it is other grounds for liability, breach of contract like misconduct or actuation of the airline employees, it will be a different base of recovery, which is based on torts, quasi-delict. The figures here mentioned is only if the cause of the death or injury or damage of property is not due to any misconduct. That's why if there will be an allegation of misconduct or bad faith, the base of recovery is not Montreal, but on our law, another provision, civil code on torts. And the prescriptive period is also different because Montreal is shorter, 2 years for damages. But the civil code on torts, it is longer, 4 years. Like making it appear that the passenger stupid by the airline company, or when the cargo was lost or the luggage was lost. But it was not just loss of cargo, it is the actuations of the airline company because they never updated the passenger what happened to the luggage. So it's a lot of actuation. I've mentioned about prescriptive period. Okay? Ito yung aaralin nyo. For me kung magtatanong sa Montreal, for me, ang importante is jurisdiction. Kasi dito may bago. The old law on Warsaw just placed an action for damages. All kinds of damages. Okay? You can file it in any of these territories, any of these places. Either territory of any one of the state parties, either before the domicile, or principal place of business, or where the contract has been made, or before the court of the place of destination. So in the case, halimbawa of Lumilier, taga Makati siya, bumili siya ng plane ticket sa UK. Ang biyahe ay British Airways ticket, biyaheng London to Rome, and napahiya siya dahil sa actuation ng stewardess. She filed a claim here in Makati City, but the case was dismissed due to lack of jurisdiction because option? British Airways, London, so UK. Place of departure, UK. Destination, Rome, Italy. So, the Philippines has no jurisdiction at all because he's just because he's a Filipino citizen. We don't use the rules of court here in jurisdiction. May special ruling siya kasi. Now, itong sabi kong bago. Kasi ngayon, if there is death or injury of passenger, there will be an additional option, which is territory of a state part in which at the time of the accident, passenger has principal and permanent residence. Nationality is not the determining factor. So example, kung meron kang asawa, AFAM, okay? Tapos yung AFAM mong asawa naging resident din ng Manila where you had your family home. Bumili ng ticket yung employer niya, British employer. Ang trip is Japan Airlines ticket, binili sa London. Ang flight, London to Tokyo. Namatay siya sa Tokyo. Can the case be filed in Philippines? As answer, yes. Why? Because there is already an additional option. The passenger has his principal and permanent residence. Nationality is not a factor. Because Warsaw Convention was made by Montreal because of this scenario that there are many victims who has no way, no recourse to file the case, more so no finances. Kaya inallow na itong principal and permanent residence. If you've read the article regarding the Korean Airlines who was shot before, decades before, there was an article there, and that is the basis where the Montreal Convention was passed. The Wandering Americans. Yun yung, kung nabasa niyo yung article na yun. Pero alam ko, hindi nabasa. Kasi ginagawa niyo, naload na kayo ng kung ano-ano, TikTok, di ba? Yun ang mas importante sa buhay niyo ngayon. Okay, so now we go with bank secrecy law. Now, for bank secrecy law, we discussed this together with peso at foreign currency. i.e., di-differentiate lang natin, mami, alin yung sa foreign currency. So, the rule is, all deposits of whatever nature are confidential, including investment in bonds. So, treasury bills are covered by bank secrecy, but not covered by PDIC, okay? Not covered by insurance. Now, these deposits cannot be examined except in these instances. So, when examination is made in the course of a special journal exam of a bank, authorized by the Monetary Board, or necessary to look into deposit to establish fraud or irregularity, or by an auditor for audit purposes, or when there's written permission. In written permission, meron tayong pro hac vice ruling on China Bank versus CA, where the father and the daughter are account holders, joint account holders, and the daughter withdrew the money from Citibank and moved it to China Bank. And the court allowed this, but only pro hac vice ruling, because this is a part of the discussion on permission of a depositor. For impeachment, this applies only to peso. Pag foreign currency cannot be examined. Ang tandaan nyo, para hindi nyo makalimutan, ay yung case ni CJ noon. CJ Corona, more than a decade ago, 2012. Gustong examine ang kanyang deposits. Pero hindi na-examine. Bakit? Kasi ang deposit niya ay foreign currency. At hindi kasama sa Foreign Currency Deposit Act ang impeachment in these cases. Kaya, dapat noon nga i-amend yung law, pero hindi na-amend. Hindi na rin na-amend kasi anong inuna ng Kongreso? Huwag na natin pag-usapan. What else? Order of competent court in case of bribery or dereliction of duty of public officials. So, dapat court order. Hindi pwedeng investigating body lang. In case the money or deposited is the subject matter of litigation. This is, there are a lot of cases explaining what do you mean by the money deposited is the subject matter of litigation. There's an old case, Yunbao versus Court of Appeals, where there's an underencoding. The amount should be 1 million, but it was underencoded to 1,000. It was discovered only after a year, and there was argument that Arit Bank should have told Yunbank on the underencoding because there's a manual of regulation of banks. So, the issue here is not recovery of the money in the deposit. The subject matter is the failure of the bank to inform about the underencoding and not the money which was deposited in the account of the drawer. So, note the meaning of the money deposited. The money itself should be the subject matter of litigation. Now, what if you stole money, you deposited half in peso, half in foreign currency? Can the money you deposited in the foreign currency account be examined? The answer is no. Why? Only the peso. Remember Republic versus Rabusa, where there is a petition for forfeiture regarding deposits of Rabusa, dollars in the account. This could not be examined, only the peso, because this covers only peso. When the money is the subject matter of litigation, is covers only peso, not foreign currency. In the case of real bank, ito medyo technical. May checking in-issue si Maningas para kay Rosaria. Hindi niya natanggap kasi someone intercepted the check. And the check was deposited in an account because the impostor opened an account misrepresenting to be Rosaria. So, the money was withdrawn. Later on, when the case was lodged, the court directed Real Bank to produce who is the impostor. But Real Bank argued this violates bank secrecy law. Is it correct? The answer is yes. Why? The subject matter should be the money itself. Here, what was stolen is the check, and the check represents money. So, the subject matter should be the actual money, not the mere money equivalent of the checks. Kasi tandaan, ang case dito, what was stolen is the check, not the money per se. So, Maningas would like to recover the money equivalent of the checks, which was paid by the bank, not the money itself, which is already in the hands of the impostor. In the case of Salvacion, which is for me a pro half-witch ruling again, an American who was convicted of rape has a deposit in foreign currency, and the victim was trying to collect. So there's an attachment. But the foreign currency deposit accept that this deposit is exempted from attachment, garnishment, other court processes. But the Supreme Court, pro hac viceuli lang to, said that it would not, it would result to a situation where the victim would be folding an empty bag. So this will result to injustice. Pero pro hac viceuli ruling lang to ha, except if squarely asked, itong sagot. Okay. The BIR, assuming that the BIR found out that hindi kasama yung paborito mong artista sa top 5 celebrity taxpayer. So the BIR decided to check its deposit with BDO. Kasi kasi siya ay celebrity na lagi nag-advertise sa BDO. Can BIR examine the BDO deposit? The answer is no. Why? Because the BIR can only do so in these 3 instances. The cedent to determine gross estate, taxpayer who filed for compromise, or specific taxpayer subject of a request for the supply of tax info from a foreign tax authority. Wala ito sa tatlo. So what the BIR is doing is a sort of fishing expedition which is not within the parameters. Who else can examine? Anti-Money Laundering Council can examine with a court order and without court order. So, peso and foreign currency without court order. Ang acronym ko dito ay KD-HAMT. In case of kidnapping, drugs, hijacking, arson, murder, terrorism, conspiracy to commit terrorism, no court order required. There are specific provisions ng anong drugs, anong mga specific crimes. KD-HAMT, kidnapping, drugs, hijacking, arson, murder, terrorism, conspiracy for terrorism, there's no court order. But if it is not KD-HAMT, there is the requirement of a court order. I will leave na lang to your criminal law professor what is the definition of kidnapping, hijacking, terrorism. Hindi na para sa akin to. Pero syempre, nandito naman sa material, pwede nyo rin namang titigan, pwede nyo mang i-post at titigan itong mga items na to. Okay? Now, if it is not KD Hunt, there must be an order of a competent court. There is an ex parte application. So what are these crimes? Anti-Graft and Corrupt Practices Act. The deposits must be related to the following activities. So, Anti-Graft and Corrupt Practices Act, may habang enumeration, plunder, robbery, illegal gambling, piracy, qualified theft. Hindi simple theft ha, kasi natanong na sa bar before, ang simple theft. Yung nakapulot ka ng alahas na hindi mo sinuli sa airport, ito yung bar scenario nun eh. That is just simple theft, not qualified theft. Estafa, smuggling, e-commerce violation, bribery, fraud, mahabang enumeration to, malversation, forgery, trafficking, forestry code violation, fisheries code violation, mining code violation, wildlife resources, national caves, carnapping, illegal possession of firearms, anti-fencing law, migrant workers, IP code, anti-photo and video voyeurism, child pornography, 7610, Securities Regulation Code, Strategic Trade Management Act, Tax Code Violation, Specific Code, OSAIC, itong pinakabago, at CSAIM, and felonies of offenses of similar nature, which is punishable under penal laws of this country, of their countries. We will go back to this when we go to Anti-Money Laundering Act. Okay? Now, sa general banking law, anong pwede ditong itanong? Kasi natanong na dito in the past, what are the different kind of banks? And differentiate one from the other. At may bago tayong classification. Okay? So, what's the difference between a bank and a quasi-bank? Because a bank's primary function is to take funds from the public in the form of deposit, and this would be lent out to the public. So, deposit taking and lending. So, only if one aspect is done, that is a quasi-bank, not a bank. Like, bumili ka ng kotse through Toyota Financing Services. Toyota Financial Services is a quasi-bank because there is no deposit taking, only lending. Okay. I said that there are different categories in bank and there's something new. Okay. Ano ang different categories? U is universal. Bakit universal? Because of the powers it exercises. Aside from the power of a commercial bank, it has the powers of investment house. It can engage in allied and non-allied enterprises. Why? Because of the high capitalization. Walang power of investment house ang commercial. Walang power to invest in non-allied ang commercial. Okay? Now, there's also a cap of 50% net worth, total investment, not more than that 50%. Why? You should not put all your eggs in one basket. That's the common saying investment. And for equity investment, any one enterprise should not exceed 25% of the net worth of the bank. But for commercial, the amount is lower. So, anong powers ng commercial banks? Tingin ko hindi mo tinatanong yun sa by enumeration. So, the amount is lowered from 50 to 35. Pareho lang yung any one enterprise. T is thrift bank. It has a law of its own, the Thrift Banks Act. Rural bank, not because of the location, but because of its market and the fact that's governed by a different law, the Rural Banks Act. Cooperative under the Cooperative Code, and Islamic bank, which must be compliant with Islamic law or Sharia law. Ano ang bago dito? Kasi we have digital banks nowadays. Okay? And digital banks, bumukas kayo ng GCash, diba? Meron dyang CIMB or UNO, whatever. Digital banks, they offer financial products and services through a digital platform. There is no physical branch or office. These are a distinct classification of banks under BSP Circular 1105. But the general banking law is not yet amended to include digital banks. Okay? What would be the nature of the bank funds deposit and the diligence to be exerted? So highly fiduciary nature, meaning of the highest degree of care. That's why the bank is supposed to know the genuine signature of its clients kasi nga of the highest degree of care. And when there is a drawee bank, collecting bank relationship, the one to be held liable is always the collecting bank because it acts as endorser. Yung real bank kanina na kaso na may impostor, nag-intercept ng cheque at nakapag-open sa real bank, recourse was being made against real bank. Why? Because real bank is the collecting bank. And the collecting bank is actually an endorser. Endorser has warranties. And of course, we are not discussing negotiable instruments anymore because that is not part of the bar exam anymore. Meron tayong also recent interpretations. In the case of Premier Development Bank, regarding this explains the degree of diligence to be exercised. What happened here? Saturnine Manalo has 5 checks. She entrusted it to her niece Saturnino for deposits. She executed SPAs. So she authorized for the deposit and the collection of the rentals. So this was deposited. 1 check was deposited. Pero when it cleared, it was transferred and pre-terminated and were released to Saturnino. Saturnino, she handed over to GenScore for investment. Another check which cleared, this was received by Saturnino, napunta na naman sa GenScore. And also for another check, more or less, all the same story happened for these 5 checks. That is why Manalo filed a complaint for collection. The bank denied liability, claiming that they relied on Manalo's Saturnino's representations. But the Supreme Court highlighted the degree of diligence to be imposed by banks. Why? So, fiduciary nature of banking requires high standards. So, this will be dealt with meticulous care. And the banks were remiss in the obligation because they allowed learning to withdraw. They referred on the SPA, but the SPA did not provide for withdrawal. The SPA only allowed collection and deposit of the amount, but not withdrawal. So the banks actually enlarged the scope of the powers of the representative. So that's the Premier Development Bank case. We're not discussing any more cross-check, collecting bank liability kasi kapag pang-nego naman ito, nakalagay lang siya doon sa Premier Development Bank case. Now, in another case, the case of Metrobank. So, the borrowers have promissory notes to cover the loans with the bank. The loans were restructured over the years. And when they asked for a computation, it appeared that they had overpayments. There was an error in the computation of Metrobank. That's why the borrowers hired their own accountant. Metrobank failed to record the payment, making the interest go up and issue receipts. That's why the borrowers asked for reconciliation and refund, but the bank said that the documents are no longer with them allegedly. So under the requirement of under banking law, the banks are supposed to exercise the high standard degree of diligence. And here, the bank argued the bank's practice is contrary to what is envisioned by law. It's not just a mere ordinary diligence or diligence of degree, degree of the diligence of good father family, which is expected of banks. It's of the highest degree of care, whether the money is only a few hundreds to millions of pesos. So, Metrobank argued that it cannot reconcile the documents anymore because they have already disposed the same, and they are relying on the provisions of Anti-Money Laundering Act that record should be only for 5 years. But this is erroneous because these records are not pursuant to the Anti-Money Laundering Act. These are records of loans, and the bank should have kept these records since the loan is still active. And also, there is evidence that the records can still be procured because the employee said, of Metrobank said that these are just stored in the warehouse. What was deleted is only the records in the computer. So it's still a fault on the part of the bank. Now, in the case of Land Bank naman versus Katadman, Land Bank received 3 checks where 2 were erroneously credited to Katadman, but Katadman already withdrew the money and promised to pay it in installments. So Katadman was directed to return the amounts, pero the CE said that the bank should also shoulder a portion because of the negligence of the employee. So is it correct that the bank should shoulder the entire amount? The depositor did not sustain any loss. What happened is nga he made an over withdrawal because the amount was erroneously credited to him. And there was no financial loss on his part. That's why the bank should not be held liable for the loss. The one to be held liable here should be Katadman. The ruling cited by the Court of Appeals, like the Franco and CMEX, are different, are not applicable because in those cases, Franco and CMEX, the bank depositor or client sustained injury because of the blunder or the dishonor of the check. But here, in this case of Land Bank vs. Katadman, the depositor or the client did not suffer injury. It was actually benefited by the erroneous credit. So Land Bank then could ask for the reimbursement of the amount. Well, at the least, Land Bank was only reprimanded for negligence because it failed to observe the highest degree of care in treating the deposit of the clients. Now, for PDIC, hindi ito isinama sa bar exam noong unang panahon. Sinasama pero recent years, tinanggal. Tapos ngayon, binalik na naman. Di ba? Parang jowa, pabalik-balik. Ayun. What do you cover by PDIC? What does PDIC cover? It covers all deposits. Insured deposits. Against what? Risk of bank runs. Hindi yung kung na-hold up yung bangko, may PDIC recovery. No, it should be another kind of insurance. PDIC covers investment deposits which are the subject of bank closures or bank runs. No PDIC for investment products. Now, lugi ang treasury bills, not covered because treasury bills are investment products. Deposits are unfunded. Deposits which are emanating from unsafe and unsound banking practice, or deposits are the proceeds of an unlawful activity under AMLA. So if the deposits came from kidnap for ransom, tandaan nyo sa Money Laundering Act, ano yung mga predicate crimes? Galing sa dangerous drugs proceeds. Yung bangko nagsara. Yung deposit na yun, hindi covered ng PDIC. Now, we have already an amendment as to the amount. Kasi ngayon, the insured deposit is up to 1 million pesos. So, in determining the amount, we have a computation. You all add up all deposits in the bank in the same right and capacity, either its own name or the name of others, and not to exceed 1 million. So, if the account is, paano pwede itanong ang PDIC maliban dun sa what kind of deposits are not covered by PDIC? Pwede rin itanong ito, in the usual way noon na the following are not covered or covered PDIC. Tapos pwede pang how much is covered by PDIC. So ito na ang computation. If there are 2 or more persons, so 50-50, unless there's different sharing stipulated. If it is a natural and juridical, the deposit should pertain to the juridical, not to the natural person. Siyempre, how can a corporation open an account except through a natural person? So the aggregate of the interest will be added up, subject to the maximum amount of 1 million. So, as illustration, So may single savings, joint, etc. You add them all up. So how much is the share of Sailor Moon? Sa joint account with Sailor Mars, 500 divided by 2, 250. Kay Tuxedo Mask, 500, 500. Kaya, 1 plus 250 plus 500 is 1.7. And the insurance coverage is 1 million. So, hanggang 1 million ang covered ng PIC. E paano yung 750? It is uninsured. Therefore, this can be recovered not through PIC, but you will be treated as one of the creditors in the liquidation of the closed bank. Okay? Now, in PIC coverage, there's always a style of recovery. People try to split up deposits. What is splitting of deposits? It happens when you have an account or accounts which is more than the maximum deposit insurance coverage, more than 1 million. You break up the accounts into 2 or more in the name of other person because you want to recover more. The transferee has no beneficial ownership, and it happened 120 days before a bank declared holiday or bank closure. So to determine who is the depositor payable by PDIC, it must be the registered owner holder of a legitimate deposit in the books. So when there are several deposit accounts, and these are maintained in the same right and capacity for the benefit of a depositor, then PDIC will recognize the said depositor as the beneficial owner. Ngayon, paano kung we chop it up? Okay. You have a 1 million deposit and you chop it into 2, nilagay mo si Mr. A yung 500,000. Is this a prohibited splitting? 500 sa'yo, 500 dun kay transfer mo to a third person. This is not a prohibited splitting because I said earlier that it must go above the maximum deposit insurance coverage. It must go above 1 million. So since the deposit is only 1 million, you can split it up without any violation because still, at the end, what you will recover will not go beyond 1 million. The aim of the law is that a person should not go beyond the 1 million threshold. So if you break it up, no violation at all. Okay? Now, there is a rule. If you go beyond the 1 million, halimbawa, you transfer it, the PDAC will recognize the transferor, meaning the new owner, as the beneficial owner unless the transferee can prove, the transferor, meaning the original owner, will be the beneficial owner unless the transferee can prove that the break and up and transfer is under these conditions. Una, it's for valid consideration. The details or information is in the records of the bank, and the copies of the documents, like contracts, agreements, is in the possession of the bank upon takeover by the PDIC. Now, for qualified relative, the qualified relative should be proven by documents, like birth certificate and marriage certificate. And qualified relative extends only to the second degree of consanguinity or affinity. We have 2 cases about this. The case of Attorney Linsangan. Kasi sa Attorney Linsangan has millions of accounts, 2 million plus, and he chopped it up. Noong una, there is an already, 2019 ruling of Linsangan where he gave it to the anak of his pamangkin. So, this is not second degree of consanguinity of affinity. Okay, remember your family tree in succession. So, in this Linsangan case, 2019, where it was transferred to the anak ng pamangkin, it's a 5th degree relative. So, it will not be covered. So, it is not a valid conveyance. But 4 years later, there's also another case of Attorney Linsangan where this time, nilagay niya tamang relatives naman. Okay, however, the law says that it must, the records should be already in the possession of the PDIC upon takeover. Here, he filed a reconsideration later on saying that he transferred the money because there is a supposed said Christmas gift. He has an affidavit of support showing that he transferred to different passbooks for his relatives with the agreement that he will just keep the interest. But again, I've said earlier, this record should be in the possession of the bank upon takeover by the PDIC. And this will only presented by Attorney Lisangan upon reconsideration. And also, para naman hindi ka panipaniwala yung script na yun. Ba? Parang dinivide mo yung pera, binigay mo ang passbook sa kanila, tapos may usapan kayo na akin yung interest. Parang walang gumagawa noon na matinong utak. Lahat ng para-paraan talaga. Okay. Now, another one. We have Anti-Money Laundering Act. Okay. Sa AMLA, paborito itanong ay predicate crimes. Okay? Tsaka, when is money laundering committed? So, covered institutions are supposed to comply with the requirements of Anti-Money Laundering Act regarding client verification, no KYC, know your client, and they're supposed to submit a list of covered and suspicious transactions. Now, they do not violate bank secrecy law, etc. when they submit this report with the council. But they are prohibited from communicating to any person the fact that such a report was made. In the case of Republic vs. Sandigan Bayan, where the first gentleman, Mike Arroyo, purchased helicopters from Lion Air, the Union Bank was unable to present documents because it was more than 5 years old already, and told that the document perhaps could be with the Anti-Money Laundering Council. The council was directed by the Sandigan Bayan to produce the records, but the council said that it is not that this matter is covered the bank secrecy law and cannot do so. They cannot divulge it. Tama ba yan? No, because the council is not one of those institutions covered. It is not just a repository of records. It's supposed to be the one implementing Anti-Money Laundering Act. So it cannot hide under the provision of being an institution who is supposed to not divulge records of depositors. Ngayon, who would be these covered institutions? Dito pwedeng magtanong. Kasi, maraming style. Kaya halimbawa, makikita nyo, example. The usual covered institutions are financial institutions, banks, non-banks, quasi-banks, insurance companies, security dealers, brokers, mutual funds, companies, entities handling currency and money of clients, jewelry dealers and traders of precious stones as a business in excess of 1 million. Kasi 500,000 lang ang normal threshold. Pero sa jewelry, 1 million. Company service providers, they provide the office, they act or look for nominee shareholders, they manage the money of their client, casinos, real estate developers, offshore game operators. By the way, for casinos, this is a result of the Bank of Bangladesh heist 10 years ago. Kung hindi nyo ito nabasa, siguro ibang pinanood nyo kasi. Okay? Offshore gaming operators, ang huli sa enumeration. This new list expands. Pero, tingnan nyo yung listahan. Okay? Remember, paano to pwede itanong? Halimbawa, OD, yung dealership ng OD. Can OD be required to submit a list of its car buyers? A list of similar to banks where banks are required to submit a list covered transaction, a list of those who have deposited or withdrawn 500,000 or transferred 500,000 above. These are covered transactions. Banks are required to submit a covered transaction report. How about sellers of cars? Are they required also like that? Audi, BMW, Benz, are they required to do that? Unfortunately, no. Kasi wala sila doon sa listahan. This is another way of circumventing the provisions of the law. Kasi hanggang real estate lang tayo, wala pa ditong car dealership. So let's see that how this law will be amended to cover this scenario. Kasi hindi sila covered institutions na who are required to submit covered transaction reports. Okay. You are a lawyer and you have a client, and based on your interview with your client, it appears that your client is engaged in illegality. Are you required to report it? Well, it excludes lawyers and accountants who act as independent legal professionals. It will compromise the confidence. These lawyers and accountants, however, are required to, are still subject to the code of respective code, either for accountants or for lawyers. Okay? Paano kung the report was made and it was made erroneously, but made in good faith? That is what we call dito, safe harbor provision. No action will lie against person who reported it in good faith. Now, for covered transaction, remember the threshold. Cash or other equivalent monetary instrument, 500,000, within 1 banking day. The requirement is not just cash. It could be other equivalent monetary instrument. So, paano kung gold bullions? Kasama yan dyan. Okay? Expensive paintings, that is an equivalent monetary instrument. Casino, single casino cash, 5 million, excess of 5 million. Real estate brokers developers, single cash, 7.5 million. Again, wala dito ang car dealership. Ito lang ang covered. So these covered institutions are required to submit the covered transaction report and suspicious transaction report. What if the amount is below 500,000? Can it still be the subject of reporting? Yes, because it can fall under suspicious transaction report because these are transactions regardless of the amount involved if these circumstances are present. There's no underlying legal trade obligation. The client not properly identified, amount not commensurate with the capacity. For example, sinabi mo na nag-open ka ng account at sinabi mo doon sa bank na ang iyong ine-expect ay deposit na allowance lang every week na 5,000 pesos. You said you are just a full-time student. Tapos may pumapasok sa yung amount every day na 10,000, 20,000. Can your account still be reported? Yes, it can fall under suspicious transaction because there is no underlying legal or trade obligation, purpose, or economic justification because you said you are just a law student, not commensurate with your capacity. So it can be perceived that this is being done to avoid being the subject of reports. It's not required that the transaction must be related to unlawful activity. Hindi yun lang ang requirement kasi it says any of these 7 circumstances. So even though if the transaction is not related to an unlawful activity, but it deviated from your profile, that can still be reported as suspicious transaction. Okay. So how is money laundering committed? Okay. So, committed by any person who, knowing that the monetary instrument represents, involves, or relates to the process of an unlawful activity. So, example, kilalang kidnap for ransom na leader, dineposit yung pera, so that is transacting. E paano kung binigay doon sa kapatid? Yung kapatid hindi naman dineposit sa bangko, itinago sa bahay. Is that kapatid liable for money laundering if the sibling knows that the brothers engaged in kidnap for ransom? Yes, because even if the money was not deposited in the bank, it includes possession. So possession, that's also money laundering. It does not need that the money goes through the monetary system that it goes through the bank. No, because mere possession, disposal, conversion is also money laundering. Or ibinili ng lupa, ibinili ng bahay at lupa, ibinili ng kotse, that will also be conversion. Acquisition, that's also money laundering. You are a lawyer. Sabi mo sa kliyente mo, ay, gantong gawin mo para maitago mo kasi yung style mo yan, bulok, huli ka agad. Can you, as a lawyer, hide under the Code of Professional Responsibility, CIPRA? Hindi. Because what you're doing is already counseling the commission of money laundering. Okay? It's different from the first scenario. What if you are the bank officer, hindi mo sinama sa report? That is also a violation because failure to submit a covert transaction report, suspicious transaction report, is also a money laundering offense. Remember the RCBC branch manager who was convicted of money laundering because of the Bank of Bangladesh heist. Okay? Kasi hindi siya nag-submit ng suspicious transaction report. This is a Justice Garland ruling, the case of Yambao versus Republic. So a freeze order was issued by the CA for the account of Yambao, peso, dollar, and vehicles. Ang ginawa ng CA, the freeze order was extended. Up to when? The bank freeze order good only for 6 months. But the CA extended it until after all the proceedings and investigations are terminated. So, the freeze order is not dependent on a separate criminal charge, much less does it depend on conviction. But for a freeze order to be issued, there must be an application ex parte and determination of probable cause. And it's just, there is a time frame. It's only good for 6 months, cannot be extended. The Yambao here kasi is the brother-in-law of General Ligot, and he was being used as a dummy to conceal the wealth. But the problem is no case was filed within the 6-month period. A freeze order cannot be issued indefinitely. So what is the remedy? The remedy is not via a freeze order, but an APO, Asset Protection Order, which is issued, Asset Preservation Order, which is issued by the RTC. Because when the CA extends it beyond the 6-month period, which is not within its power anymore, it will be a violation of the right of the legal to due process, the right to be presumed innocent, because it will bar the ligots from enjoying their property when in the first place they have not yet been held guilty of any crime where they're suspected of committing. So there is a remedy which can be used by filing appropriate asset preservation order in the RTC. Okay, the Zimbabwe versus Republic. Mahaba lang. Now, let's go to New Central Bank Act. Itong New Central Bank Act, hindi ito kasama sa bar ng mga nakaraang taon. Tapos bigla na namang binuhay, pinasok na naman. Pero nung panahon ko, kasama to sa bar. Okay, so, sa New Central Bank Act, anong pwedeng tanong? The concept of a lender of last resort. Ano itong lender of last resort? It means that the BSP can grant loans and advances to banks not more than 7 days without collateral for the purpose of providing liquidity, so that there will be no collapse of the banking system, because people might panic and lose trust in the entire banking system, not only in that particular bank. But remember, it says liquidity, not solvency. So if the bank has solvency problems, hindi pwedeng mag-apply ang lender of last resort because it speaks only of liquidity, meaning the bank has more assets than liabilities, but the assets are tied up in non-cash like land, building, not solid cash. Natatanong dito, in the past, ang currency and legal tender. Okay? This currency and legal tender are not interchangeable because currency means all Philippine notes and coins. Legal tender, however, is that kind of money which a debtor can compel a creditor to accept. Paano tinatanong ang currency and legal tender noon sa bar? Kahit sa bar ko tinanong na ito. Ngayon kasi, meron na tayong ceilings. Okay? Halimbawa, may utang ka. Ang utang mo 1 million pesos. Pwede mo bang bayaran yung 1 million pesos using coins? There is a cap for 20 pesos up to 2,000 pesos only. 20 peso coin for 1 centavo. Hindi pa ako nakakita ng 1 centavo. Meron ba nito? Up to 200 pesos. So, nung panahon ko, paano ito tinanong ba? Sumakay ka ng jeep, ang pera mo buo, binigay mo 500. Sabi ng manong driver, wala ka bang barya? Wala po. So, sa galit ng manong driver, sinuklian ka ng magkano minimum fare? 500 minus 13, no? Ang sukli sa'yo ay 487 pesos na tig mamiso. So, anong gagawin mo? Ibabato mo sa jeep ni driver o tatanggapin mo? You're compelled to accept because that 1 peso coin is good up to 2,000 pesos. Okay? So, naalala ko tuloy, para huwag kayong matulog, meron akong kaibigan na practicing lawyer. Tuwang-tuwa siya. May kliyente sa kanya nag-ibot isang Manila envelope, attorney's fees. So, syempre niya binuklat sa harap ng kliyente. Tuwang-tuwa siya, tinanggap niya yung Manila envelope. Makapal. Tapos umalis ng lawyer. Pag alis ng lawyer, anong kliyente, binuksan attorney yung envelope. Anong laman? Ilang bungkos, 10 bungkos ng bills na tig 20 pesos. Di magkano isang bungkos? Di ba 2,000? So, binigyan siya pala 10,000 isang Manila envelope. Okay? So, if it is in bills, wala tayong maximum. Yung maximum natin lang ay nasa points. Okay? Now, meron tayong jurisprudence regarding borrowing. It's the case of BSP versus Ombudsman. Because borrowings, banks was under supervision by the BSP. Okay? And there's ongoing supervision. The examiners are prohibited from banking. In this case, Hamurabo was a bank officer 1 in the supervision examining sector, borrowed from Rural Bank of Kimba, where he was conducting regular exam. And there is a provision prohibiting borrowing. Okay. Here, the officer borrowed, and number 2, it was not disclosed to the BSP. So, there was a violation. What is the proof that the borrowing is not on arm's length transaction? Meaning, arm's length basis. Because the loan was approved immediately the following day. There was no also proper disclosure. And there is exertion of undue influence as an effect. So, the arm's length transaction was not met, making Hamurabo liable for the unauthorized bank loans. Okay. Isa pang pwedeng matanong ay conservator and liquidator. Because when the monetary board, the supervisory examining department, finds that a bank or quasi-bank is in the state of continuing inability or unwillingness to maintain a condition of liquidity, the monetary board can appoint a conservator. The conservator then will step into the shoes of the board of directors of the bank. And it will be good only for a year. Conservatorship cannot be more than a year. If it exceeds, then it will not be conservatorship anymore. It will be a receivership na. Okay? Now, however, if the monetary board finds that the bank, quasi-bank, has notified the BSP of a closure or has been dormant for 60 days, cannot pay liabilities they fall due, has insufficient realizable assets, cannot continue business without involving probable losses, or violated a CDO, or which has become final, The Monetary Board can summarily, without need for prior hearing, forbid the institution from doing business. The PDIC will be designated as receiver. So, anong tawag sa doctrine na yan? Kaya may closed It's known as the closed now, hear later doctrine.
A law degree is a marathon. Every tool you choose is an investment. Don't just settle. Choose the reliable. Precision matters. Bigger, clearer fonts to keep your focus sharp. Stay ahead of the recitation. Our integrated ribbon marker saves you time when it matters most. Built for the demands of the modern student. Fully updated and aligned with your curriculum. CentralBooks Codals is an investment trusted by law students and thousands of law practitioners.
Okay, so what is closed now, hear later doctrine? After mentioning ano yung requirements, kaya nga, closed now, hear later, there is no prior warning. The bank is immediately closed. Why? As a measure of protection. It's similar to a search warrant. Siyempre, hindi ka mag-a-announce ng magsa-search ka muna ng search warrant application. Otherwise, wala ka nang mahuhuli. So, swift action is pulled for the part of BSP so that the money will not be dissipated. Is there violation of due process? The bank was closed. There is no prior hearing. Due process does require prior hearing. Also, hearing can come in later after the closure. So there is no violation. This action was final executory, ang remedy, certiorari. But the one who can file a petition for certiorari is not the board of directors. It is the stockholders of record representing majority of the capital stock. In the case of Vivas versus Monetary Board, sabi ng bangko, bakit kami dire-diretsong receivership? Bakit hindi ba pwedeng dumaan muna ng conservatorship? This is not a requirement that there should have been conservatorship first before receivership because this is the discretion of the Monetary Board. So, bird's eye view, the difference between the two. In conservatorship, the bank can continue business, but the conservator takes the place of the board. In receivership, it cannot do business anymore. So, between the two, anong mas malala? It is one of receivership because the bank cannot do business anymore. Okay? Is a bank which is under conservatorship or receivership enter into contracts? It can enter contracts. A bank under receivership can enter into contracts as long as it is not in the conduct of banking business. Okay? Conservatorship still can enter into contracts. It's just that the conservator steps into the shoes of the board of directors because the board of directors will not act. It's the conservator. Pero pag receivership, wala ng board. Is the receiver, the PDIC is the statutorily designated receiver for the banks. So the bank cannot do business anymore as a result. If it's closed, can no longer be rehabilitated. So liquidation will follow. Now, IP. Okay. IP, among all of the topics, I think this is the last topic. Ito yung pinakamagalaw. Kasi ang dami laging bagong jurisprudence. Hindi siya tulad ng ibang case law na stagnant, like partnership. Kung ano noon, yung pa rin, ba? But IP is fast. Okay. How is this usually asked in a bar? Differentiate a patent from trademark and copyright. Sa tatlong ito, ang paboritong tanong sa bar ay trademark and copyright. Patent, hindi gaano. Tsaka jurisprudence sa patent kasi konti. Karamihan ng jurisprudence na sa trademark. Bakit? Well, they said that we are a nation not of inventors but of copycats. May katotohanan naman talaga rin. Diba? Manood ka ng pelikulang Hollywood. Pag may sinabing inventor, hindi mo makikita Pilipinong inventor. Either Russian, Indian, Chinese, puti. Pero walang Filipino inventor. Diba? Now, patent would cover inventions. Trademark covers goods or services. Copyright covers literary, artistic, scholarly, and scientific works. patent and trademarks are registered with IPO. But copyrights are registered in the IPO also because there's a Bureau of Copyright already, also with the National Library, ORIAN, and Supreme Court Library for Legal Works, but not for purposes of giving you a right, because copyright is granted from the moment of creation. So it's only for record purposes only. The duration of the right of patent is 20 years from filing, no renewal. Trademark is 10 years for registration, there's renewal. And copyright, we have to distinguish between economic and moral right. Because economic right and moral right of integrity is lifetime plus 50 years, lifetime of the author. But the moral right of attribution is in perpetuity after death. Okay. For patent cases, meron tayong bago. This is about patent infringement, direct and indirect infringement. The tuna processors case. Actually, there are two tuna processors case. Isang old tuna processors case na tanong na sa bar at itong bagong tuna processors case. Okay. When you say direct infringement, it refers to making, using, offering for sale, selling, or porting the product obtained from the process or unauthorized use of the process. Indirect infringement results to the person's act of inducing another to infringe a patent. So this is by inducement. Or you contribute to the activity of another. Kaya nga contributory. So for contributory, there must be knowledge on the infringer's part that the component is used for infringing a patent invention is not suitable for substantial non-infringing use. So for indirect infringement to happen, there must be a direct infringement. There's no contributory if there is no direct infringement. So let's illustrate this. Okay. Halimbawa, may isang patent. It has 4 claims, A, B, C, and D. Now, product B uses the 4 claims plus the 5th one, additional element A. This is literal infringement because all the claims are copied, diba? A, B, C, and D are copied. Even if it makes a dagdag, the claims are already copied. So that is direct infringement. This is a literal infringement. Now, what if what we change is we get only 3. So there's a patented product A. Then product B took only the 3, left the other 1. There is no literal infringement or equivalent infringement because it does not include the element D, one of the elements. So, in case 1, the first case, there's direct infringement because all of the elements were copied, even if it added an additional 1. There is, in the second case, one of the elements is absent. So, there is no direct infringement. Here, what if what happened is there's someone who induced? So, yung kanina, yung who introduces the 5th element. But a third party, company X, induces the producer of product B to use element A. So he is the one who provides elements A. This third party, company X, is liable for contributory infringement. But the producer of product B is the one who is liable for direct infringement. Okay, so kaya required na for a contributory, dapat merong direct infringer. So let's go now to the Frescomar case. So Yamauka owned the patent for curing tuna meat. Tuna processors was given the right to license the Yamauka patent. Tuna processors entered into license agreement with Frescomar, which processes the seafood products and smoke in canisters. Tuna processors then learned that Frescomar is producing the filtered smoke in can to Hawaiian. And Frescomar hired the employees of Pescarich to build the smoke machine. So Hawaiian is also selling seafood products and also the cans. So was there infringement by Frescomar of the Yamauka patent? And how about Hawaiian? Is Hawaiian liable for contributory infringement? Okay. The Yamaco patent covers the method of curing tuna meat. It is not a patent for the smoke machine. The patent is the method of curing the tuna. So, the smoke machine being not one of the claims under the Yamaco patent, then there can be no infringement because it's not one of those included. The claim of Yamaco is this fourth step, the method of curing the meat where it is burnt up to 250 degrees to 400. It's passed through, the smoke is passed through a filter. That there's a cooling between 0 to 5 degrees, and the tuna meat exposed to 0 to 5 degrees. Prescomar did not perform all of the elements because they ended with the smoke production. And also, this smoke is not even an indirect product. Remember, this is tuna. So what is the indirect product of tuna? It has something to do also with tuna. Because when you say directly, it means it's obtained from the patented process without an attempt to avoid, this directly obtained from patented process when the infringer deliberately performed the patent process without an attempt to avoid infringement. So, the patent is about the method of curing the tuna meat. Therefore, if there would be an indirect product, it will just be something to do with tuna and not something about the smoke. So, the smoke was produced after the burning, the smoking material, and filtering the smoke. So, the filtered smoke is not a product, even direct or indirect, of curing the tuna meat. So, there is no liability then for direct infringement. Therefore, if there is no direct infringer, there is also no contributory infringer. Take note of this tuna processor's case kasi hindi pa ito natatanong. Ito also ang landmark case on direct and indirect infringement. Okay. Now, let's go to trademarks. Sa trademarks, walang kamatayan pa rin ang dominancy and holistic test. How do you know which of the two tests apply? Tandaan na ang words na ginamit natin sa definition of infringement ay dominant feature. Therefore, we are following the dominancy test, not anymore the holistic test, okay? Because the law says dominant, prevalent features. There's no more holistic test. Holistic test was expressly abandoned when we used the new Taiwan Colin case in 2021. The old 2015 Taiwan Colin case no longer applicable because in the old Taiwan Colin case, these two marks are allowed to coexist. One is television, one is transformers, etc. But the Supreme Court allowed both to coexist because they belong to different channels of trade, different pricing mechanisms, so a buyer will not be deceived into buying an item. But when the 2021 Colin case came in, sabi ng Supreme Court, well, the old Colin case used the holistic test. We are now already with the dominancy test. And when we say the word Colin, you don't know whether you're referring to the one with the italics or the one with the all capital, K-O-L-I-N. The fact that they belong to different categories under these classifications is material because, number one, they're not really different. Both are electronic. And number two, you cannot use as a guide the NIST classification. Why? The NIST classification is not permanent. It changes from year to year. And if the Supreme Court already abandoned this service classification in determining whether they are related or non-related at all. Now, there's also another new ruling. The Farlin bottle case is Cymar versus Farling. Alam ko tong Farlin to kasi gumamit ako dito sa panganay kong anak. Okay. Cymar is the Philippine domestic corporation engaged in the manufacturing, marketing of these baby products, including bottles. And Farling Industrial is the corporation, Chinese corporation, engaged also in the manufacturing sale of baby products. Farling filed a petition with the IPO for the cancellation of the Farling mark because Cymar was able to obtain certificate of registration for the Farlin mark. When the Farlin is coined from the name of the corporation, Farling Industrial. And this Farling was already registered in China. The Signmark's proof that it was the first user is that it has registration. And Farling, however, countered that it authorized only Signmark to sell. It was only a distributor because they have shipping documents. Now, who between the two would have the right? Remember, the one who was able to obtain registration is Signmark. But even if it was able to obtain registration, registration can be canceled because the registration is fraudulent. Okay. What then would constitute bad faith in the trademark registration? It means that the applicant has knowledge of the prior creation and use of another, of an identical or similar mark. So, fraud here is not just an inaccurate claim as to the origin. It is intentional making false claims to take advantage of another's goodwill. Here, because of the timing, it is obvious that the Signmark has, with full knowledge of the Farling's history and use of the mark, was still registered it. So it was a registration made in bad faith. Remember, Signmark was just a distributor. Okay. How about the fact that Farling waived copyright on the trademark? Copyright and trademark are two different intellectual property rights. So waiver of copyright does not mean waiver also of trademark. So even if Signmark asked Farling to execute a waiver of copyright over the design so that it will be registered as a copyright in its own name, it does not mean that it's also a waiver of the trademark. Why? Because I've said earlier, these are three different intellectual property rights: patent, trademark, and copyright. And there is no encroachment of one over the other. And authorization for a copyright will not extend to a trademark and vice versa. Okay. Now, there is a procedure regarding opposition. So, pwede itong matanong regarding procedure in opposition. Here, there is the Farling is asking for the cancellation. The marks use the word Farling. And I've said earlier that there's proof in as early as in the 80s on advertisement that the Farling mark is used by Farling Industrial. But even with this, Farling cannot claim damage because it has no registration or application for registered to mark at the time of the application of Signmark. These applications of Signmark were filed before Farling filed its own application in 2007. Therefore, it can only claim for damages under a different provision on cancellation and opposition cases from the basic mark. Okay. So, there is another case. This is a case of Justice Garland. MC versus LR Foods. Ang paborito kong lechon. Okay. MC and LR Foods. Who between the two has a better right? We look down at the history. Okay. Because the spouses Luntok are marketing the roasted pigs under the name LR's Lechon. So it gained popularity over the decades. But without LR Foods knowledge, MZ Foods was also selling LR's Lechon. This time with the letter Z. So S versus Z. Sa mga hindi po taga Manila, and yung LR's at saka S saka Z ay halos magkakalapit lang na tindahan in the past. Okay. So, people thought that MZ, the one LR's with a Z, is a branch or franchisee of LR Foods. LR Foods filed with the IPO an application for registration of the mark LR's Lechon. And it was issued certificates, but MC still used the LR's Lechon mark, causing confusion on the public. The argument of MC is that LR Food is not the owner because LR Foods is a mere alter ego of the spouse's luntok. The spouse luntok is the one who has rights of the mark because LR is the name of the owners. Luntok Rodriguez family name. So, kaya L and R, Luntok Rodriguez. That's why the owner now of LR, the trademark LRs, is not LR Foods, but the estate of the spouse's Luntok. And since the owners of MZ Foods and LR Foods are just cousins, all of them should enjoy using the mark LRs. Is this correct? Okay. The Supreme Court said that LR Foods is the legal owner. Why? Because when LR Foods incorporated, the spouse Luntok transferred to LR's Lechon ownership of the LR's Lechon mark. And IPO also issued certificate of registration in favor of LR Foods as proof that indeed spouse Luntok transferred their unincorporated business to LR Foods. So the heirs have no right at all over the mark. Okay? So, labanan ng lechon. Now, let's go now to, so unfair competition din ang diniscuss din dito regarding passing off of their product because the products are the same, LRs and MC, and people thought that LRs with a Z is just synonymous with one with an S. As a result, there's indeed passing off of the product. So, I will not repeat anymore the discussion regarding dominancy and holistic test. For trademark dilution, there's a new jurisprudence. Dilution means either dilution by blurring or dilution by tarnishment. When you blur, you impair the distinctiveness of the famous mark. When you dilute by tarnishment, it harms the reputation of the mark. Example, Levi's jeans and Levi's motorcycle. These are two different things. Even if Levi's jeans has no connection at all with the tricycle or motorcycle, the use of the Levi's on the motorcycle will tarnish Levi's because if the motorcycle is substandard, people will think that Levi's is substandard. In dilution by blurring, there's no harming of the reputation, but you just impair the distinctiveness of the famous mark. We have the landmark case of Suyen versus Danhak. This is about Agent Bond. Because Suyen Bench is selling gel with the brand Agent Bond. And the one who complained is the James Bond franchise, who owns James Bond, Bond Girl 007. The Supreme Court ruled in favor of Danhak, the one who owns James Bond and Bond Girl 007. Why? The use of the Agent Bond really resulted confusion. Because James Bond is actually a fictional spy created where James Bond is an agent. So, Agent Bond. James Bond is an agent. And all of the James Bond characters have the same feature. A man with well-kempt hair. And the product of Suyen is gel used for styling hair. So people would this would suggest a connection with the James Bond and the Agent Bond. Okay? So talo si Bench. Now, Lacoste versus Crocodile. Okay? In the case of Lacoste versus Crocodile has trademark registration as well. And Lacoste also has registration. But the difference is the mark, how Lacoste looks like and how Crocodile looked like. Lacoste has this crocodile looking on the right and the body has inverted triangles. Crocodile looks on the left. It has a design element and a word element, and the body has solid lines. The form arrangement, overall presentation is different. And there is no trademark dilution because there's no showing that crocodile, the famed Lacoste mark, because it had been coexisting with other jurisdictions like Japan. trivia, bumili ako last summer ng crocodile. The first time ko makakita ng crocodile doon sa Japan. Kasing presyo lang siya ng Lacoste, pero mas maganda ang quality ng crocodile kesa Lacoste. Ayan ha, trivia. Dalawang binili kong blouse. Now, to justify that the mark of Lacoste was defamed, Lacoste used two surveys. Necessity, using Project Copycat. And there are two bases, necessity and trustworthiness. Okay. However, although the necessity aspect was proven because the court finds that it's a need to conduct survey, yung second ang hindi na-meet, yung trustworthiness. Okay. Why? The survey conducted did not define the universe. There was no proper representative sample. What was sampled were respondents from GMA, 450. It did not say the population size. Is it the relevant consuming public? Remember that Lacoste and Cocoda are not cheap brands. These are expensive brands. Shirts costing 4,000 to 5,000 pesos. But the survey conducted did not say that the people they surveyed are the correct population. Dapat, they said that the population should be those who are buying the brand. Okay, and not just any random person. That's why the survey failed. Okay, the use of the survey failed. Survey evidence is important because it is also survey evidence which was the basis of Ginebra versus Ginebra San Miguel and Tadway. In the battle between Ginebra San Miguel and Tadway, Ginebra San Miguel won again because of the survey. The mark Ginebra actually is you looking at the different kinds of marks would fall under this. A coined or fanciful mark are those marks which are invented. They have no real meaning. Okay, well, like we say Google. You can find it in the dictionary, or Kodak to me, which for us we mean camera picture. They have the greatest chance of being registered. Arbitrary marks, they have meaning, but they have no logical relation. Like if we say Apple, people do not look at Apple, the fruit, but Apple, the computer or the cell phone. Suggestive, they give a hint on the quality or attribute, but do not really describe this. So if not bordering on descriptive, it can be allowed. Descriptive, they just describe the feature, kaya nga it's not allowed generally. And generic, this because we're using the species or object to which they apply. Okay, like you say pan de Manila, when you say pan, it means bread, so you cannot appropriate the word pan, not eligible for protection. So we'll go back to Ginebra. When you say Ginebra, what mark is Ginebra? Is it generic? One of those among the five, diba? Is it generic? No. Why? To know whether it is generic, you'll have to look at public perception. And this is where survey evidence came. Because based on the public perception, based on the survey, when you say Ginebra, people think about the enterprise, not on the literal meaning of Ginebra. Because Ginebra actually is a word coming from the Netherlands. It means juniper, juniper berry flavored grain. So the public understands Ginebra to mean the enterprise and not the class of product which it represents. Because if the public understands the word to refer to the product of a particular enterprise, then that word is not generic, but a distinctive one. So Ginebra is not generic, but distinctive because of the understanding of the public. The basis is the survey. Now, how come this time, iba result ng survey? Because the survey in Lacoste is wrong. The survey in Ginebra is correct. They conducted two surveys, and their sample are the proper universe. Their universe is a population of 6 million gin drinkers, those belonging to the lower class, urban and rural household of a certain age range, elementary, high school education. So they are using the correct population size, and 80% or more of these people answer that when they see Ginebra, they associate it with Ginebra San Miguel, and they do not know Genever or the juniper berry flavored cream. That's why Ginebra won. Kaya parang ito ay implied abandonment na rin ng Old Ginebra San Miguel case. Di ba meron tayong Old Ginebra San Miguel case na sinabing Pilsen, the argument there by Beer na Beer, that pale Pilsen is a kind of light Bohemian beer in the state of Pilsen in Czechoslovakia. Wala na Czechoslovakia ngayon kasi naghiwalay na. Czech Republic na yon at Czechoslovakia. Huwag kayo pupunta doon. Mag-ingat kayo papunta doon. Maraming pickpocket. Hindi naman ako na dengoy. Okay. So, iba ang ruling na doon. Kasi nga, parang impliedly inabandon na ang ruling na yon as an effect. At saka tingin nagtatanungin yun kasi ito na ang bagong doctrine sa Ginebra San Miguel. So, Ginebra then is actually a descriptive mark. It is now subject to trademark protection under the doctrine of secondary meaning or the doctrine of distinctiveness. So, there are certain doctrines also to remember. The doctrine of foreign equivalence. It says that resort to dictionary translation in order to ascertain whether a foreign word is generic or not. So you look at the dictionary translation. It is generic with respect to a certain product if the English translation concedes a generic meaning in relation to such product. But there are exceptions. Example is if the ordinary purchaser will not likely stop and translate the foreign word because the word already has a different meaning on public perception, or the word is obscure or uncommon or dead already like Latin, or when the word has developed an alternate meaning in the relevant marketplace, or it's unlikely that purchasers would translate the mark because of marketplace circumstances of the commercial setting in which the mark is being used. Okay. Now, for copyright, sa tingin ko, ang pwedeng itanong dito ay musical copyright cases because this is developing. Okay. What do these pictures have something in common? Sizzling Plate and Icebergs are both restaurants that they play music coming from the radio, and the radio has amplifiers. Okay, so everywhere, and people within the restaurant can hear the piping music coming from the loudspeakers. In the case of the Grill Bar and Restaurant, they have a band where the bands will be performing copyrighted songs, and they will play also recordings of copyrighted music if they are not playing the songs. So the question is, do this establishment need to get a license? Do they need to pay royalties if they were playing music using the loudspeakers, or the bands will be performing the songs? Ang term nyo pala, kasi bata na kayo, is cover, di ba? If they would be making a cover, the Supreme Court said, yes, this is a performance. So, although the radio station was licensed by the copyright owner, the playing of the music using loudspeaker is still another performance. What is the doctrine of multiple performances? It means that a radio or television creates a copyrightable performance separate from the broadcast per se. So if there is a reception, it's translated into audible sound, there was actually a reproduction because you use electrical instrumentalities. So, di ba, you use loudspeaker. The original author, the author of the work, has in mind that the ones who will listen to him, it would be the direct audience within the family circle. That's why if you use loudspeakers, there will be already another public, a new public, which the author never contemplated. So there should be payment of royalties anew, because there was already payment of royalties by the radio station, but only for the family circle. How about the doctrine of fair use? Can this be used by these restaurants? For fairs to apply, the performance should be private and free of charge or strictly for a charitable or religious institution or society. This four-factor test for fair use was not met in this case. Why? Because looking at the purpose and character of the use, the establishments are commercial in nature. The songs are creative. They are not factual. There is exact reproduction. So, amount of substantiality, bagsak. And also because if you will allow unrestricted use, it would have impact on restaurants, on bars and clubs, which can be a potential market for the songs of the authors of the work. So, there is a violation. You can apply for factor S. Paano naman yung business exemption and homestyle exemption? Because U.S. copyright law provides for business exemption as well as homestyle exemption. This exemption says you allow it if the establishment is small, certain square feet, or number of tables or chairs. Homestyle says if you are using ordinary homestyle equipment, those normally found in the homes, private homes. But the problem is, there is no business exemption in the TRIPS agreement. It did not meet the requirement. So it is a violation. Remember, we are signatories in the TRIPS agreement as well as Berne Convention. And homestyle exemption, however, is okay. It's compliant. How about our intellectual property code? Kung ito ay sa WIPO. The Intellectual Property Code has no similar exemption. We don't have business exemption. We don't have homestyle exemption. Kaya nga, ito ay developing case. Sinabi ng Supreme Court, it recognized these small restaurants, mom and pop establishments. How about them? So, the courts would have to balance the interest of these. So, in the meantime, the matter was thrown to Congress. Congress' attention should be drawn to this deficiency. And in the meantime, the court should strike a balance between the rights of the owners to be compensated and the right of the public to enjoy. So, habang hindi pa nare-resolve ng Congress, because this was thrown to Congress, thrown to the courts, to have a balance for this. So, ngayon, wala pa tayong aasahan. Kasi nakikita nyo naman sa Kongreso, hindi naman paggawa ng batas ang inuuna nila. Kaya huwag kayong umasa na mababago ang Intellectual Property Code as soon as expected. Kasi hindi nila priority yan. So, for bar process, tandaan itong mga sinabi kong cases. Okay. So, I'm left again with my 5 minutes useless words of advice. And I usually leave it with alamat of two-piece chicken joy, which you can also find in my pre-week notes, which will be published, which is actually ongoing printing. Siguro by the time that you're watching it now, meron na kayong kopya kasi naka-release na siya. Okay. Alamat ng two-piece chicken joy. Kasi, bakit alamat ng two-piece chicken joy? Kasi nung bar exam, itong baon ko. Okay. Bar exams, anong oras? 8:00, diba? So, anong oras ako bumili ng Chicken Joy? 5:30. So, 5:30, pagdating ng classroom, daladala ko na yan. Ngayon, pagpasok ko ng classroom, nung panahon namin, ang venue isa lang, Lasal. Okay. Doon ako sa isang classroom na wala akong kakilala since day 1. Kasi hindi ko naman alam na dapat pala, pag mag-apply ka for bar exam, isa kayong grupo para kayo yung magkakasama sa kwarto. So, mag-isa lang ako doon na walang kaibigan. And there was this group na maingay. So, commercial law. Nung pagbukas agad ng page 1, asigaw agad nung leader nung maingay na grupo ay, ang dali ng work. Napatingin lang kami. Siyempre, bahala kayo. And then, nag-bell. Lunch came, so I had to eat inside Lasal. Doon sa ilalim ng, kayo yung nag-exam sa Lasal, yun yung, doon sa mga may puno na semento, yung upuan. Okay? So, doon ako kumakain. And my baon is, of course, the 2-piece chicken joy. And habang kinakain ko, hindi ko makain. Why? 5:30. Diyos ko, di basa-basa na mamawis ng chicken. Hindi na maluto. So, pinagtiyagaan ko na lang yung balat, tapos yung laman, pinapakain ko doon sa mga aso, doon sa lasal. Matataba ang aso sa lasal, tsaka mababait sila. Okay. Now, yung leader ng isang grupo, nandun sa kabilang puno, lumapit siya. Siguro nakita niya na wala akong ganang kumain. Akala niya siguro may kinalaman yung gana ko ng pagkain doon sa exam. So sabi ng leader ng grupo, Tol, ang dali ng work, no? 1 year, 1 day. Nag-gets ko agad yung sinabi niya. Kasi there was a question in commercial law about redemption period. But it was a two-pronged question. The question there was, Corporation X and Mr. Timbot. And I know that you have studied already law on redemption. That if you speak of natural person, redemption period is 1 year. But for juridical person, it is registration or 3 months, whichever comes first. So, dapat naman sila pagmulta. Pero sabi niya agad, di ba ang dali ng work, 1 year ho? And a bad trip ako. Sabi ko, anong 1 year? Di ba sagot doon, it depends. Because Corporation X and Mr. Timon at nagtahimik na rin yung grupo. At hindi na rin sila kumain. So, pare-pareho kami hindi kumain, but with a different reason. Hindi ako kumain kasi hindi masarap ang baon tong 2-piece chicken joy. Kaya nga alamat ng 2-piece chicken joy, huwag kayong magbabaon ng 2-piece chicken joy. So, ang baon nyo nilang dapat ay burger or sandwich. Huwag yung egg ha, kasi lang ako mag-LBN. Gano'n na lang, walang 2-piece chicken joy. Okay. Now, on another lesson is that, do not debate your answer with someone else. Why? Kasi kung nakipag-debate ka, tapos ikaw yung mali, eh hindi ka makakasagot na sa next subject kasi affected ka, di ba? Now, kung ikaw naman yung tama, tapos yung kadebate mo yung mali, tapos best friend mo, magkakaroon ka ng kaaway sa araw mo. Kasi, syempre, naiisip na yung sagot na mali. Kaya dapat manhimig na ikaw. Tsaka, move on to the next exam, di ba? Para pag-judge. Be ready to move on. So, with that useless piece of advice, I don't know if it's useless or useful to some, good luck for the bar exam. And I always have good wishes. I wish to see you in court, but never in Victoria Court. Okay? Thank you.
Thank you so much, Judge Tambasacan, for sharing your expertise and valuable insights in commercial law. We hope today's lecture has helped our law students and our bar candidates to strengthen their understanding of the subject and better prepare for the bar exams. Before we end, here is the schedule of our upcoming Best Pre-Week Ever Season 3 lecture series. Civil Law, August 26, Labor Law, August 26, Criminal Law, August 28, Legal and Judicial Ethics, August 28, Remedial Law, Civil Procedure and Criminal Procedure, September 1, Remedial Law, Special Proceedings and Evidence, September 1, and finally, Taxation Law, September 3. We would also like to recognize our main sponsors for this initiative, CentralBooks and Rex Education. On behalf of the Philippine Association of Law Schools, we extend our sincere gratitude for your generous support. Your partnership has been instrumental in making Best Pre-Week Ever Season 3 possible. We would also like to acknowledge our event partners, the PUP College of Law, and the Association of Law Students of the Philippines, Nationall. Thank you once again for joining us today. This is Hannah from PUP College of Law, your host for the Best Pre-Week Ever Season 3. See you at our next lecture session. God bless and good luck to all of our future lawyers.